Hmm.
Whether the
Okay.
secretary has been nominated or not, that is the question.
Please, your Lord. Unfortunately, I'm at the same stand. Like what-
Okay, we bring for some time. Mr. Mahmood is not available today.
The date may be
Yes,
fixed.
yes, but this bench is very uncertain. The day when this bench is available, we'll have it.
Fix the date so that it can be constituted.
No,
I said
that will not be proper. That will not be proper. But we'll have it very soon. If it's delayed, then you make a mention, or we can direct the registry for a bench constitution. Right now, without there being a bench available, we'll not fix a date. Today, there is some special permission for Arunachal for a
Right.
matter that is why we are here. Sri, who's for the you're for the review applicant?
I'm-
Sri BD Das, Learned Senior Counsel.
SHTI is supposed to produce the record.
Okay. Learned Senior Counsel for the applicant. Full stop. However, a prayer for adjournment has been made on behalf of Sri M.U. Mahmood, Learned Counsel for the opposite party, writ petitioner. Full stop. As this particular court is in the midst of a division bench, the present roster, comma, registry may leave this case as and when this bench is available.
Lord, your Lord, I said then we will not be able to reach the matter if it is delayed.
No, it will not be
Sir,
delayed. Now, if
last
it's extraordinary, delay, just inform us. We'll do something else. But most likely, there are chances. Yes, next. Mr. Tapin,
Lordship.
what is this?
Lordship,
Okay, there's one more. There's
Yeah.
one more. There's one more matter of the principal bench.
But in a small correction in your lordship order at page 8.
Page 8.
Page 8 is the order, madam. The correction thoughts for in page 10.
Yes.
First two line, madam.
Hmm.
It is submitted on behalf of the petitioner that building in question is not a commercial structure but is for residential purpose of the petition. But the permission which is sought for for a building of commercial use on the petitioner's individual, personal, privately.
Not for residential purpose.
No, ma'am. The building permission is sought for a commercial building.
It's for a commercial structure.
Commercial use on the private land of the petitioner.
Now, will this same
Same order, my lord.
same order will be also
Yes, my lord.
applicable?
Yes, my lord will find.
Huh?
Only thing
Uh,
is that that particular one is a semi-private land where he will construct a building for commercial.
No, then what? Where in which construction it will be applicable? The requirement of FRCC.
In fact, your lordship, in a similar situation, page 53 in the writ petition, my lord,
Hmm.
has passed the same order. It was
No, that
also,
we have understood.
my lord,
But the requirement of forest will be in which, what kind of cases? In cases of construction?
in cases of government construction, my lord, government
Contracts and all.
contracts and all.
Contracts.
Government contracts.
Yeah.
Okay, heard. 3B Kaushik Learned Counsel for the applicant writ petitioner, who by means of this application has sought for a modification of the correction in the order dated 21/12/2023, passed in the connected writ petition WPC 7511 of 2023, full stop. Also heard. Shreyas Bora, Learned Standing Counsel.
Yeah.
GMD, DA, full stop para. By referring to the aforesaid order dated 21/12/2023, Sri Kaushik, the Learned Counsel has submitted that in the said order, there is an observation that the structure in question is not a commercial structure, but is for residential purpose of the petitioner. Full stop. He clarifies that the structure is indeed a commercial structure, which, however, is being constructed on the private land of the petitioner, and there is no involvement of any government department
Right.
for the same. Full stop. Para. Sri Bora, the Learned Standing Council, does not oppose, submits that he would not oppose in principle to the clarification oblique correction sought for. Full stop. Para. In view of the aforesaid submissions, comma, the extent I is disposed of by correcting the observations appearing in the aforesaid order dated so and so. Full stop. Accordingly, the sentence within inverted comma, it is submitted, huh? Is may be read as certainly. It is submitted on behalf of the petitioner that though the building is a commercial structure, comma, it is constructed on the private land of the petitioner. The I accordingly stands disposed of. Full stop. The order passed today may be read as a part of the order dated so and so passed in the writ petition.
Highly obliged. Great.
Yeah, step number one, how many MCTS need be? So he was directed to the take note over there. MCT.
There is no representation on behalf of the on the behalf of the state. Full stop. Para. Registry may reflect. Registry is directed to reflect the name of Sri M. Chetia,
M.
Learned GA, Assam.
But I am happy for the review applicant.
Yes.
So without the pass the order method on 29 on page 4,
Page.
page 240, 11 will be 242.
242. Okay.
But that was basically when confined to the interpretation of a particular clause 1.7.4. But we had given an interpretation method
142 or 240.
what 240.
Okay. Yes.
So now we have it was submitted that the requirement of clause 1.7.4 could be satisfied if in a particular year, if the amount is 158 crore and up. And from the on behalf of the state it was submitted that is the average. And also has taken a view that submission made by us is not prima facie acceptable. So therefore the increment of past that now what we have we could not point it out for your chief. The issue method. What was the issue method? The issue was my tender was rejected on the ground that I have not satisfied the clause 1.4. So therefore, the interpretation of that particular clause was required. But ultimately now accepting your lordship's observation there, what would be the consequence? The tender, various tender clause of the RFP does not say if anyone fails to fulfill the condition. In that case, the tender is liable to be rejected. Nowhere it is mentioned. Rather, the bid processing, my lord, evaluation criteria that has been given, your lordship may kindly come to my lord page 87. Schedule D. That is the core issue, whether they had the power and authority to reject the tender on the basis of the non-fulfillment of the clause 1.7.4.
87.
87. This is the, my lord, technical bid evaluation process. Here it is marking system. The lordship will find
Yes.
bid opening committee during the opening of the technical bid shall verify the following documents uploaded during bid submission, original downloaded as a prerequisite for carrying out for further evaluation of the technical responsiveness of the bidder. Proof of payment of bid fee of 25,000 only. Then, my lord, is clause 2,
Yes.
and then 6.2. In addition to fulfillment of later at Schedule C, my lord, relates to the mandatory documents to be uploaded. So now they will, my lord, make the marks, my lord, here. Experience in similar nature work. This relates to, my lord, clause 1.7.2. So for that purpose, Form C has to be filled up. Then your lordship will find the third column is performance of work Form C. That relates to, my lord, clause 1.7.4. And your lordship will find
But in a review,
this,
is
my
there
lord,
any scope?
yes, my lord, this is the issue which we could not brought it to your lordship notice. Actually, this had this
No, see,
document.
this issue we can definitely take up in your final hearing if you if it is taken for final disposal. But to review an order, you have to make out a case which is apparent on the face of
Face
it.
of the record. So that's what, my lord, these
And
documents.
these are new things which you
No,
are
these are,
trying
these
to.
are not. These were part of the, my lord.
No, these are new submissions which you are trying to make.
My lord, these were the materials available on record, my
No,
lord.
this
and
this
lordship,
this was
which-
no, no,
which-
first. See, it's very easy for us to reject your petition, but that we are not. We will not do. You may have a very good point now that since there is no clause in the contract document that tender can be bid can be rejected only because of non-fulfillment of that particular clause. That argument may be a valid argument we have to examine, but that argument was not made on the earlier
but
occasion.
that's what we have failed to brought to your lordship notice
Then
about this
it
particular
cannot
document.
be a
and
matter of review. You can file an appeal.
my lord,
Review
what-
is something we have to.
my lord, what
See,
was-
you have to review is not something seeing the correctness of the order. Review is something which is
No,
apparent
my
on the
lord,
face of it.
not the lordship finding with regard to the, my lord, interpretation of this clause 1.7.
No, that finding may be erroneous.
We accept. my lord, we are not
Finding may
disputing
be erroneous for you. The appellate court is available. That is a part of the system. We
Lordship,
cannot be right every time.
Lordship, in fact, on this issue, Lordship, appeal was filed, Lordship. Interim was not granted by the Lordship appellate court, Lordship. Then they subsequently they withdrawn, Lordship.
that. We have withdrawn. It is not that,
And
my
the
lord,
same
it is
submission
not-
is-
not- it is
same
not granted, my lord.
submission
It
is
is-
Have you
being
have
over
have you have you
Lordship.
given that appellate order
Yes.
here?
Yes.
Where?
Yes.
Page
That page your lordship will find 249.
249.
As because these issues could not be raised, my lord, so therefore the appeal was withdrawn. And
To file afresh.
lord,
Lordship.
You
Appeal,
file a fresh appeal.
no, my lord will find, my lord, I have given my statement why we did not go for the appeal as well, because my lord.
Not a case
my lord,
for
what-
review.
what
Not
we
a
are
case. Not a
trying-
case for review.
My lord, will find the second, my lord, aspect of the matter, my lord, which was not within our knowledge, which we have got subsequent. That is with regard to clause 1.7.2.
Not within your knowledge in spite of due diligence.
Yes.
Clause was not within your knowledge.
No, my lord, not that, my lord. The document which was, my lord, submitted by the private respondent number 7, that was forged. This forged document, my lord, we did not have the knowledge. subsequently, we have,
You file an additional affidavit in the writ petition.
subsequently, we have got it, my lord, from the, my
It's
lord,
not yet been filed. Lordship.
You file an additional affidavit in the writ petition. This will be one of the additional grounds and get the writ petition disposed of as early as possible. We had
We have-
given some kind of a protection, I think, that no final or any action
my lord,
taken.
that is not
Yeah.
there, therefore, my lord, the entire, my lord, otherwise your lordship will kindly say, my lord, so far as the power on the review, my lord, will this particular issue which was not addressed by the court, my lord, perhaps that may be a ground for review. For that, my lord, if I'm permitted, my lord, I may cite a my lord, decision of, my lord, for 1954, and subsequently other decisions are also there. Which would say, my lord, that is, my lord, if the issues were there and that was not touched by the court, in that case, it is a, my lord, proper case for, my lord, review.
Where is the issue?
My lord.
You have not even pleaded. Without a pleading, can there be an issue?
No, no, my lord, this issue was this issue was pleaded in the, my lord, writ petition that we could not, my lord, point out before your lordship, my lord, on
Have
that-
you must have gone through by the case of Dragonra issues in the writ petition not argued are deemed to be considered and rejected. But we are not even
No,
going to
no,
that.
that will be,
We
that,
are not even going to that
No, my
extent.
lord, no,
This
that-
is a very interim kind of
My
a
lord, my
observation.
lord, that's what, my lord, we have, my lord, withdrawn the appeal because this, my lord, was not argued before your lordship at the time of, my lord, consideration of the prayer, my lord, on that day. So therefore, we have preferred the, my lord, review. of
Sorry,
the-
Mr. Thank you. Not a case for review. Heard. Is anything, Mr. Tapin?
No, Lordship.
Heard Sri Vijayasekar Learned Senior Counsel for the
This
applicant.
Various judgments should go to show, my lord, it's
Oblig-
perhaps a
writ
case for, my
petitioner
lord, review.
who by means of this application is has prayed for review of the order dated 29/1/2024 passed by this court in the connected writ petition WPC 23 of 2024. Full stop. Para. This court, while considering the writ petition 242, you have said.
Look,
Writ petition is Lordship 23 of the
Had while considering the writ petition had initially passed an order on 24/1/2024 whereby the matter was directed to be listed for motion again on 29/1/2024 to enable the learned senior government advocate State of Arunachal Pradesh to obtain instructions. Full stop. It was also observed that in the event the financial bids are opened, opened on that date, no final orders of allotment be passed till the next date fixed. Full stop. Para. The matter was accordingly listed for consideration on 29/1/2024 when Sri S. Tapin, learned senior government advocate, Arunachal Pradesh, had obtained the instructions. Full stop. This court, after considering the submissions of the learned counsel for the petitioner, as well as the learned state counsel, had issued notice and on consideration of the interim prayer had expressed an opinion that the interpretation sought to be given on behalf of the petitioner, qua clause 1.7.4 of the tender document was not legally tenable, was prima facie not legally tenable. Full stop. However, it was observed that all action taken pursuant to the RFP in question would be subject to the outcome of the writ petition. Full stop. It is the aforesaid observation in respect of which the present review has been sought for. Full stop. Para.
So, my lord, I'm not against that observation. I'm against the vacation of the interim, We did not have the, we could not, test the materials. Further
no, no,
required to investigate
Tara
the,
Gottlieb,
interim period.
this court had already had also made an observation that the interim directions made on 24/1/2024 stood vacated. That's what it is. This, huh? The review has been sought for, full stop. The London Senior Counsel for the applicant has submitted that though the interpretation, though the observations made by this court with regard to the interpretation of clause 1.7.4 may be acceptable, comma, there are no clause in the tender document which empowers the department to reject a tender for non-fulfillment of this 8th clause. Full stop. He, in this regard, comma, he refers to the Schedule D of the RFP, which finds place in page 87. Full stop. Under Schedule D, comma, it is submitted that the procedure for technical bid evaluation has been laid down, which also envisages allotment of marks under various heads, and there is no provision for rejection of a tender on non-fulfillment of the aforesaid clause. Full stop. He further submits that the applicant has, comma, in the meantime, gathered additional information, which, according to the applicant, would make the bid of the private respondent.
By which the documents which he has submitted, it's a false document. He has submitted a false document based on which he become eligible.
Okay, listen to us. Okay, Gulu. Untenable in law, as the same contains forged documents. Full stop. Para. Sri S. Tapin, who is heard online, has however submitted that the aforesaid grounds cannot be treated to be grounds for review of an order. Full stop. He has also pointed out that being aggrieved by the aforesaid order, comma, a writ appeal was preferred, being WA 3 of 2024, which, however, was withdrawn on 8/2/2024, full stop. He submits that such withdrawal was made with liberty to file afresh, and there was no contemplation to file a review application. Full stop. He otherwise submits that the applicant has not met the requirements of filing a review petition wherein the parameters are well settled. Full stop, Sarah. Sri Saikia, the Learned Senior Counsel, in his rejoinder, has submitted that the fact of preferring a writ appeal is not only disclosed in the writ appeal in this application, but the order itself,
But I have
dated
also,
8/2/2024, has been annexed.
and also stated in paragraph 14,
Disclosed, we have said.
no, the reason of preparing the this review application.
Full stop. He has also submitted that the
Page 13.
application contains reasons for preferring this review application. Full stop, para. After considering the rival submissions, comma, this court is of the opinion that the parameters of entertaining a review application are well settled. Full stop. The at a paragraph my huh? The Honorable Supreme Court in the latest case of so and so, by taking into consideration the earlier landmark cases, has laid down as follows. Full stop. Para. This court is of the view that the grounds of review are maybe grounds which can be raised in an appeal, wherein the correctness of the order dated 29/1/2024 can be put to challenge. Full stop. However, to make out a case of review, comma, it is incumbent upon a party to make out a case of patent and a patent error apparent on the face of it, or discovery of new facts which were not within the knowledge of the party, or any other sufficient reasons. Full stop. Para. This court is of the view that
I have
the grounds taken do not fulfill any of the requirement. Full stop. This court has also noticed that while withdrawing the writ appeal, comma, no liberty to file a review was taken or granted, and the liberty was only to file a fresh appeal, fresh writ appeal. Full stop. Para. In view of the above, comma, this court finds
something which I wanted
does
to
not
cite
find
that-
any merits in this application, and accordingly, the same is dismissed.
something which I was, it should go to show the case of that. May I cite to
We can put the judgments, not going to help. We'll put the judgments, latest judgments.
the palpable, my lord, what has the
No,
order, my lord,
we'll not hear.
I'm not challenging the order on the ground of.
We
the-
have passed the order, Mr. Singh.
At least,
You
my lord,
challenge it in the appeal.
at least some liberty, at least I can raise this by a additional FTP or mistake
No,
and.
why it's up to you.
raise before.
It's for you. Is there any bar for fighting an additional affidavit? There's no bar.
Okay.